Welcome to Uncivil Law. Today's case revolves around a guy named Prigmore. Prigmore was discovered during a routine traffic stop, and he was found with contraband in his car, namely firearms that he was not permitted to have because he's a convicted felon. So Mr. Prigmore's arrest is not as interesting as what happened next, his mental stability to be at trial. So there was some indications early on that all was not well. He tried to plead, but the court was so concerned with his sanity they didn't accept his plea. And he went through a string of lawyers who tried to represent him unsuccessfully because the lawyers were unable to work with him. So we pick up the action at court, where the Bureau of Prisons has to evaluate whether or not he's sane enough to even stand trial. Pursuant to the court's order, Dr. Chanel, who worked for the Bureau of Prisons, was able to evaluate Mr. Prigmore. Because he was already in custody awaiting trial, they were able to evaluate him over a number of weeks and multiple different sessions. Additionally, the Bureau of Prisons looked into his medical records and court records to get a more full evaluation of Mr. Prigmore's sanity. The Bureau of Prisons was able to determine that Mr. Prigmore was sane, but suffering from advanced personality disorder. Perhaps one of the more advanced cases of advanced personality disorder, but sane nevertheless. In Mr. Prigmore's case, he was marked with disregard for societal norms and unwillingness to accept responsibility for their own behavior. Also demonstrating an inability to work with others, including other prior counsel who had already been fired or left due to inability to work with him. But that diagnosis doesn't lead to insanity. Dr. Chanel determined that Prigmore understood the charges and he could explain matters, but he simply chose not to. He knew that he was supposed to be respectful and he knew how to act to get his point across, but he was unwilling to work with an attorney that did not conform to his tight expectations. While those expectations might be unrealistic, perhaps not even in his best interest, they are not the result of a mental illness. He's fully capable of working with his attorney if he chooses to be so. Pursuant to the court's order, Dr. Chanel, who worked with the Bureau of Prisons, was able to evaluate Mr. Prigmore over the series of weeks as he awaited trial and determining whether or not he was sane to stand in that trial. Dr. Chanel was able to do multiple different interviews, as well as determine his history based on prior medical records and prior court histories, as he had already been convicted of felonies prior. In determining whether or not he was sane to stand trial, they diagnosed him with antisocial personality disorder. As the name somewhat implies, he doesn't like to play well with others. He has a marked disregard for societal standards and values, and unwillingness to accept responsibility for their own behavior. Dr. Chanel was able to determine that Prigmore understood all the charges and that he did know how to conduct himself, but he simply chose not to, including not willing to work with an attorney who did not conform to whatever his expectations were, even if those expectations were against his own interests. In other words, he's fully capable of working with an attorney if he chooses to be so. Mental fitness is not the same thing as legal sanity. To be legally insane, you have to not understand what's going on, either at the incident, or at the time of trial. If at the time of the incident, but you're sane now, you can plead mental insanity or diminished capacity as part of the defense. If not mentally insane at the time, but insane now, you can plead unfitness to stand trial. So we're looking to see if there's any sort of mental disability that's precluding him from understanding the charges. Does he not understand what is going on? Is he unable to assist his counsel because of some sort of mental defect? The psychologist, in looking at this, determined that no, he was able to understand the charges, as they were able to review him over a number of weeks and able to discuss the charges over a number of weeks. He understood what was going on, he simply refused to cooperate. And that was not a mental disability. It might be a mental trait of his, but he understands and is competent to make the choice, and he chooses not to make the choice. A person's unwillingness to cooperate with the court or their attorney does not insanity make. The court, however, was somewhat shocked by these conclusions, because the court, of course, also had the misfortune of examining the defendant on multiple different occasions. In fact, the government itself was surprised by it. So much so, the government itself asked for a hearing to allow the parties to cross-examine the doctor. You don't see that every day. The government themselves are looking at this and like, we don't think this guy is sane. We don't think the doctor is right. We want to cross-examine him. So the doctor was cross-examined and testimony was offered. It turned out that this particular doctor determined that a person was mentally unable to assist their lawyer or mentally unable to assist at trial about 25% of the times in their 500 diagnoses. However, for this particular defendant, the doctor's opinion remained firm. APD is not the same thing as incompetence. They might have difficulty working effectively with an attorney, but they're able to distinguish the ability from willingness. Quoting, "I don't believe that APD impacts ability. It's a rational choice they make on their part. It's not a mental illness. Schizophrenia, for example, in which there's clear impairment in thinking, which prevents a person from having certain beliefs or behaving in certain ways. A person with antisocial personality disorder is aware of the consequences of their behavior and is aware they could choose to approach it in a different way. They simply choose not to." After this initial determination by the Bureau of Prison Psychologists, the court concluded that he was fit to stand trial, and things seemed to proceed well at first. In fact, the defendant eventually decided that he wanted to plead guilty, so the court scheduled a plea change discussion. But it was all a deception. During the supposed plea change conference, he engaged instead in a lengthy discussion about his innocence. The court declined to allow this change of plea because it wasn't a change of plea at all, and then moved it to chambers for further discussion. Prigmore, the defendant, acknowledged that he had duped his attorney into believing it was a plea change conference when it really wasn't. Noting again that they were somewhat shocked about the determination of competence, the judge asked the lawyer's opinion on mental competence. The prosecutor themselves also expressed concern over competence and relayed that even to the Marshal Service. Apparently, Prigmore had been throwing his own waste in jail, and the judge agreed that if this was personality disorder, it was the worst case they've ever seen. So Mr. Prigmore's shenanigans are no means limited to court. They also extend to the jail system, where he has been apparently throwing his own waste at his jailers. And the court also notes that it has had the misfortune of examining him, and his own defense lawyers and the prosecution, all of which are looking at this and thinking, we're not quite sure this guy is totally with it. We're not sure about that one, so maybe we need another look at his mental evaluation. The judge therefore ordered a second evaluation, this time by a local forensic psychologist not affiliated with the Bureau of Prisons, and stated that in their layman diagnosis, Prigmore was nuts. So the court thinks this guy is cuckoo for Cocoa Puffs. This second doctor evaluated Prigmore and performed several different tests. Their conclusions also aligned with the Bureau of Prisons recommendations. Prigmore was competent to stand trial and did have antisocial personality disorder. The second doctor admitted the antics would make him a difficult client to work with, but rejected the notion that it stemmed from mental disability. In short, he did understand the consequences. The court again expressed some surprise at this because they noted that if it wasn't the second consecutive mental status evaluation, they wouldn't believe it. The prosecutor also agreed, noting that the doctor's report was an eye-opener in terms of mental health. The conclusions they reach are sound, but just seeing Mr. Prigmore in case, I honestly don't know how counsel deals with it on a level that's actually allowing them to be effective. Despite the concerns, it deferred to the experts and continued towards trial. The court is in disbelief, the prosecutor is in disbelief, the defense lawyer is in disbelief. But the court, being a good court, looks primarily to the facts. What are the facts? So the court notes that there are two expert opinions that exist at this point. The defense has not asked for an independent evaluation. You might be asking yourself, why did the court come to this conclusion if it's in such disbelief? The courts, of course, are determiners of fact. While they can, of course, rely on their own observations about what happens in their own courtroom, they should and must look to expert opinion. The court, of course, knows that these experts have considered this much longer than the court, have had more chances to evaluate them under more circumstances, and have conducted more thorough tests. Not to mention the fact that these are experts in mental health, as opposed to the court, where when it comes to mental health, he is a layman, perhaps a slightly more educated layman than some, given the number of people that walk through his court, but a layman nevertheless. The court therefore defers to the experts at hand. The court, being a good court, looks to the evidence that's available, and the evidence that's available seems to suggest this guy is in fact sane. Despite all his antics in court, despite all the facts that are available, the court looks at it based on the evidence submitted and reaches the conclusion this guy is competent. He's a pain in the butt, but he's competent. You might wonder next how things turned out at trial. The presentation of evidence was fairly unremarkable, all things considered, but against advice of counsel, Mr. Prigmore decided to take the stand in his own defense. This is, after all, and perhaps unfortunately, one of the decisions that only the client gets to make, no matter how much their lawyer would really prefer they not. So Mr. Prigmore over here decides to take the stand. So on direct, he apparently decides to testify that he was advised by a former attorney that he had immunity from all prosecution from the nonviolent crimes due to his work as a confidential informant. The problem for Mr. Prigmore is that there is no evidence of any kind that such an agreement ever existed. Every witness called to this supposed deal denied it existed, leading the court to eventually conclude, by proof of absolute certainty, there is no deal. These witnesses, by the way, also include his own prior defense lawyer, who apparently advised him. The defense lawyer's like, nope, didn't happen. Things got worse for Mr. Prigmore on cross when he openly confessed to the charges. Question: on October the 21st of 2017, in the backseat of that SUV, correct? Correct. All right, and that high-point firearm was underneath of you, correct? Correct. That was your gun, wasn't it? Correct. The ammunition inside of it was yours, correct? Well, I purchased the gun, so the ammunition came with the gun. It was my gun. You thought I'm going to lie. I'm not going to lie. After short deliberation, they found him guilty on all counts. Perhaps unsurprisingly to the possession by a felon of a gun and firearms. It was my gun. It was my ammo. I'm not going to lie. He's found guilty. It wasn't probably going to go well for Mr. Prigmore, no matter what he did, but this certainly isn't helping. So he was found very, very guilty. But wait, it gets worse, because during sentencing, the district court gave Prigmore another opportunity to explain his immunization theory in detail. Why can't I be charged? It wasn't long before this far-fetched theory turned into the bizarre. After declaring that his former attorney had given him permission to sell drugs, which his former attorney denies, Prigmore stated that he wanted to sell drugs to get addicts off the needle. When the judge asked Prigmore to elaborate on this statement, he relayed an incomprehensible analogy involving a 6th grade classroom and a substitute teacher, and then stated that he was helping addicts by selling them pharmaceuticals, a safer drug you can't overdose on. Prigmore also informed the court that he had filed a complaint with the state bar against his former lawyer, accusing his former lawyer of having intimate relationships with him and his girlfriend, a belief which he then attributed to months in solitary confinement. My mind wanders, go back and forth. At one point in time, I really thought that because of blackouts. I don't know. I thought he was trying to kill me. I thought all types of stuff was going on. Based on this, the court asked the psychologist to do another competency evaluation. After reviewing the transcripts that they'd sent, the doctor confirmed the initial diagnosis. The content of the writings and testimony is provocative and contains themes that are attention-grabbing. They subsequently create the impression that he is divorced from reality. His claims, nevertheless, do not reflect the presence of an underlying psychotic thought process. They are not delusional. They are instead consistent with attempts to manipulate the system to achieve a desired outcome. Manipulation to the aforementioned degree is undoubtedly remarkable. It does not reflect the presence of an underlying mental disease. It is instead illustrative of the previously assigned diagnosis. He is accordingly willing to say anything, no matter how outlandish, in an attempt to get his needs met. The tendency that he exhibits with regard to advancing his assertions, while also remarkable, further fails to represent a mental disease and instead reflects an attempt to wear people down. And then it went forward with sentencing and sentenced him to 120 months in jail for the violations that were present. That brings us to the end of the case of United States of America versus William Prigmore. And now it's time for my color of law. I give this a blue rating of reasoned. This guy obviously has troubles, but the court is, after all, the best position as the fact finder to look at this and look at the available evidence. And the court gave him every chance to be evaluated multiple different times. The Court of Appeals, reviewing this, defers to the trial court as the finder of fact and finds that despite evidence to the contrary, which might suggest an opposite conclusion, the conclusion the court reached cannot be thought to be an abuse of discretion, which is the standard required. So as to the trial court, I give them a blue. As to the Court of Appeals, I give them a blue. Both are reasoned, even though there might be some information to the contrary. And that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.